Thank you for attending our second panel in the Ohio's Opioid Settlement Panel series titled Ohio's Opioid Settlement, Proceeds and Plans for Impact, co-hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law and Harm Reduction, Ohio. Before we begin, we just have a few notes we'd like to share with you. First, to streamline the appearance of the event today, we suggest that you hide non-video participants. To do that, click on the three dots at the top right corner of any participant box that has their video off and click Hide Non-Video Participants. Second, we want to draw your attention to the Q&A function at the bottom of the Zoom window. You may submit questions at any time during the presentation. Third, please note that auto-generated transcription has been enabled for this event. To change how you view the automated transcription or to hide it, click Live Transcript in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Micah?
Thank you, Holly. Welcome everyone to this second installment in this series on Ohio's opioid settlements. Today we're going to be discussing proceeds and plans for impact, and I want to thank the Drug Enforcement and Policy Center at Ohio State's Moritz College of Law and Harm Reduction, Ohio for co-sponsoring this panel and this whole series. Just as background for those of you who missed the first session, in the first session, we provided background on the opioid crisis, on the litigation against the opioid manufacturers, distributors, and retailers that has been brought on behalf of states and cities and counties, on the broad outlines of the settlements that have been reached so far, and on some of the history of the Tobacco Master Settlement Agreement of the late 1990s and some of the challenges in ensuring that that settlement money was spent for its intended purpose. So if you missed that panel, I would encourage you after this one to go back and look at it. It is on the Drug Enforcement and Policy Center's website and also on the Moritz College of Law YouTube page. This panel is going to pick up from there and talk more about the details of the settlements that have been reached so far and the plans for spending that money at the state and regional and local levels, and also how Ohio's approach to spending the settlement proceeds compares to other states. And we have three terrific speakers that I'm very excited to hear from. I will introduce them all now in the order that they will be speaking in, and then we can try to go as seamlessly as we can from one speaker to another. And then at the end, I will come back and moderate the discussion using the questions that you all submit through the Q&A function. So just would encourage you as we're going along, as questions occur to you, please submit them through the Q&A function, and then I will get to as many questions as we can after all three speakers have had an opportunity to introduce themselves and talk a bit about their piece of this puzzle. So I will introduce the speakers. First up will be Jonathan Blanton, who is Deputy Attorney General for Major Litigation at the Office of Ohio Attorney General David Yost. In that role, he manages and has managed some of the office's highest profile civil matters, including the litigation against opioid manufacturers and distributors, which we will discuss today. Combined with the lawsuits filed by local jurisdictions in Ohio, these lawsuits have already resulted in more than $1 billion in settlements, with more lawsuits and proceedings that are still underway. Jonathan previously served as chief of the Consumer Protection section of the Ohio Attorney General's office, and he has extensive experience as a criminal prosecutor, including 10 years as the Jackson County, Ohio prosecutor. And he is a graduate of Ohio University and the University of Kentucky College of Law. So he'll speak first on the perspective from the Attorney General's office. And then next up will be Zach Klein, who has served as the city attorney for the city of Columbus since January of 2018 and was recently reelected to serve a second term in that position. Prior to being elected as city attorney, he was a member of Columbus City Council and served for 2 years as the council president. He has had a distinguished career in public service, which I won't go through in detail, but includes serving in the White House in the office of then Vice President Joe Biden, and working as the Deputy Chief of Legal Services in the Ohio Attorney General's office. Relevant to this panel, he oversaw the litigation against opioid manufacturers and distributors on behalf of the city of Columbus and made the decision for Columbus to join the One Ohio Settlement Agreement, which we will discuss. He is a graduate of The Ohio State University and of Capital University Law School. And then last but not least will be Christine Minhee, who is a visiting scholar at the University of Washington School of Law in Seattle. After graduating from law school in 2019, she received the prestigious Open Society Foundation Soros Justice Fellowship. And as part of that fellowship, she created the website opioidsettlementtracker.com. And as the name implies, it was intended to be and has become the go-to website for tracking opioid settlements and how states are planning to spend the money from those settlements. She currently works on advocacy projects relating to how state and local governments are planning to spend the proceeds from the opioid litigation and the settlements. And she is a graduate of Stanford University and the University of Washington School of Law, where she was named a Dean's Medalist. So I will turn it over to the speakers in that order, with Jonathan Blanton starting first.
Thank you very much. Happy to be here. I have to start with my usual disclaimer, which is what I say, the opinions that I express, and any comments that I may make today are based upon my own experiences, interpretations of the facts of the documents, and also the litigation, the history. Attorney General Yost has not reviewed or approved this, so this one's on me. So thank you very much for the opportunity to take part in this. This is a very important conversation about really the future of Ohio's recovery and how we, as a state, in partnership with the local communities, move forward, how we remediate this crisis, and how we move on to that next step, not just of curing this, but making sure that we don't experience something similar in the future. In order to really understand the settlement structure and the One Ohio structure, it's important to have a little bit of history, because Ohio is in a somewhat unique situation amongst the states, because through the partnership with the cities, the counties, the villages, and their council, and a lot of good faith, hard fought negotiation, we were able to create a structure and a means to provide the 3 opioid distributors, and hopefully very soon Johnson & Johnson, with near global peace. And that has put Ohio really ahead of the curve in terms of the ability to settle. We are one of only, I believe, 2 states now that have effectively settled with the 3 distributors. New York is the other. And we were able to do it as not an AG-driven settlement, but a partnered settlement. By way of history, the attorneys general became involved in the opioid sphere, looking at opioid manufacturers and distributors, probably beginning in about 2015. I had the opportunity, as part of Attorney General DeWine's team, to take part in some very early discussions examining the opioid crisis from a marketing and distribution perspective. I had a very good background in it, a pretty good understanding of what the pill crisis looked like, having served 10 years in the heart of pill country, where the prescription drug crisis was certainly peaking in the early to mid 2000s. As we began moving into investigations and conversations with the companies, we remained hopeful that there could be a reasonably timed national settlement. It became clear that that was not going to occur, and as a result, in May of 2017, then Attorney General DeWine filed suit against Cardinal, McKesson, and AmerisourceBergen, and also a company called Miami Lucan, which is a smaller distributor. I'll call this the big 3 because that's how we have. The May suit, May 2017, was the opioid manufacturers. We later sued the distributors in February of 2018. That's the big 3. Throughout that time, we had been engaged in discussions with a small group of states, attorneys general, trying to bring these companies into compliance, focusing really on remediation and abatement and reforming conduct. We want to make sure that whatever had happened in the past that led to this wouldn't happen in the future. The discussions went on through 2018, culminating in a series of discussions at the Opioid MDL hosted by overseen by Judge Dan Polster in the Northern District of Ohio. And we were making some progress there. In October of 2019, just ahead of heading into trials with Summit Cuyahoga County, the big three distributors and a number of other companies proposed a settlement to the attorneys general that was widely publicized, and Attorney General Yost believed was insufficient, as did a number of other attorneys general. At that point in time, Ohio and 13 other states formed what we called the Better Deal Coalition. And our goal was to bring a little bit more accountability and bring a little bit more dollars to the table by working together. We were able to partner eventually with the remaining states, and bring a hopefully national solution together. But that wasn't done just by the states. And I've talked about the attorneys general so far, because in the background of all this was a significant amount of litigation by cities, counties, and townships. Those were consolidated into over 2,000 cases in front of Judge Polster in the opioid MDL. Because of that, we developed a very, very close working relationship with counsel for some of the political subdivisions and the leadership of the National Plaintiffs Executive Committee. In that fall of 2019 timeframe, with what we had hoped would be a national settlement looking like it may not occur, Governor DeWine, Attorney General Yost, and Ohio's local leaders began convening a series of meetings. We started out at the governor's residence to sit down and say, all right, what can an Ohio path forward look like? Because what we need to figure out was, first, if there is a settlement, how are proceeds divided amongst all of these litigating parties against all the levels of government to make sure that they're maximized for the best use. Through those conversations, we developed a working group that began meeting out at the Department of Public Safety and came up with what is called the One Ohio Plan. The One Ohio Plan offers two key things for defendants. One is it brings all of Ohio together to talk about if there is a settlement, how that settlement is going to be divided, how it's going to be split, and how everyone comes to the table. The second thing it did, which was unique, is it created a process and a structure for an Ohio-only settlement. Up until this point, the companies were very, very focused, and really the attorneys general, everyone else, were focused on trying to develop a national settlement, something that would bring widespread global peace to these companies. With the October 2019 offer and the division that happened amongst the states and amongst political subdivisions as well, we decided together with our subdivision partners that Ohio might need to go alone. And we developed a path forward for doing that. It was a negotiating committee consisting of the Attorney General and representatives of the Plaintiffs Executive Committee and counsel for local political subdivisions. We did that because together we could provide widespread relief, and we could bring together a significant coalition in Ohio to resolve cases against the companies, resolve the liability, and offer them the best hope of certainty that they could have. In February of 2020, the One Ohio Plan was released at a meeting where it was really published to Ohio's local governments en masse for the first time. The One Ohio Plan was innovative, it was unique, and really it was visionary in a lot of ways, because we tried to solve a lot of the problems that were alleged to have happened with the tobacco litigation, with tobacco settlement proceeds. The proceeds would be split 30% to Ohio's political subdivisions, cities, states, or cities, counties, villages, and townships on an allocation formula. 15% will go to the state of Ohio for opioid abatement purposes, and 55% is to be placed in a foundation that will then distribute those proceeds regionally based on an agreed set of criteria, but also with an agreed focus on abatement strategies. And there are three key parts of abatement strategies. There are three levels in there. One is the strategies for community recovery, which is the hyper-local stuff, the what can you do in each city, county, and township. The strategies for statewide innovation recovery, which is to promote statewide change and regional development for prevention, treatment, recovery support, and community recovery. And then probably most importantly, I think that's not talked about a lot, is strategies for sustainability. The reason that we started discussing a private foundation or not-for-profit is to create a route for continued relief, to protect money from improper use, to protect it from being diverted when it feels like the opioid crisis is waning, and when the needs of local governments and state governments come to the forefront in terms of infrastructure or structural changes. We didn't get here overnight. The crisis didn't develop overnight. We decided it was together that we needed to develop a solution that would last and would make sure that monies are available not just to fight the opioid crisis, but as addiction develops, as new crises erupt and emerge, that we could face them together with some significant funding and also an eye toward innovation. In September of this year, we were able to ink a settlement with the big three distributors, Cardinal, McKesson, and AmerisourceBergen. If we get full participation from Ohio's political subdivisions, that's going to result in about $808 million flowing into Ohio for abatement purposes over 18 years, or 18 payments, about 17 years. We were able to, thanks to tremendous work by City Attorney Zach Klein and other local officials and lawyers who are representing political subdivisions throughout the state, deliver about 99%, just over 99% of the litigating population in those deals. They agreed to sign on, they agreed to participate, waive their actions against the companies and provide global peace. We're in the mid-90s in terms of the non-litigation litigating population for communities above 10,000. And that work's going to continue. We've got a little more time before that's final calculations going to be held for us. But we've experienced success through teamwork. We've experienced success through innovation. And we've experienced success through honest, hard-fought negotiations with the companies and with each other. I appreciate City Attorney Klein's participation in this. A lot of great people were in that room. A lot of great things happened, and I look forward to seeing how this recovery proceeds and how Ohio's communities put these funds to use to fight the epidemic.
Well, how's everyone doing? I'm Zach Klein. I'm the Columbus City Attorney, and thank you, Jonathan, for those remarks and for the accolades and praise that you have given me and others across the litigating subdivisions that represent the cities and counties and townships in the state of Ohio. I agree, and to turn the table back to you, like the leadership that you have provided has been instrumental in getting everyone together to reach this global settlement for Ohio, which I think is unique. It is innovative. It is important. To build off on what Jonathan has already laid the foundation on, I think, as with any settlement, there's a lot of different competing interests that come into play. And so my perspective, I guess, if I'm going to give any disclaimer here, is my perspective from the city of Columbus, that I'm not obviously talking on behalf of every county or city, large or small, but it is also based on conversations that I have had during the course of this litigation with lawyers and elected officials in those subdivisions as we try to come to a resolution. And in those competing interests, there, as you can imagine, a lot of frankly just distrust originally of how we were going to get this done in a way that was satisfactory to a lot of different interests in groups. You had some distrust between local governments and the state of Ohio of whether we could trust what they were going to do to deliver money to the subdivisions, to the counties where, frankly, we thought the money, the bulk of the money should be spent. And that's not one specific individual. It was, it started with some of the erosion of the local government fund by the legislature and previous governors. So there was a little bit of distrust there. Frankly, there was some distrust amongst the smaller cities and counties versus the larger cities and counties. There was distrust of whether we were going to strong arm and try to get all the money for ourselves, leaving the smaller municipalities or townships without any sort of resolution and funding to take care of the problems that they also had in their community. And I think to underscore what Jonathan said, that's what makes really the achievement of One Ohio so special, was all of us able to come together with an open mind in good faith to build a program where we thought addressed, from a checks and balances standpoint, addressed some of the concerns that we had as litigants to ensure that the people that we represented, in my instance, the people of the city of Columbus, got their fair share for the damage these companies have caused through the proliferation of opioids in our communities. So in creating the One Ohio settlement and signing on to it, the establishment of the foundation and then therefore the regions. So Columbus and Franklin County is in Region 1. It's obviously the largest region. It's the largest population base in the state of Ohio, Franklin County, City of Columbus. The partnership that we then had to work with our friends in Franklin County, and what we're currently doing right now, is determining what structure makes sense for us in Region 1. So each of the individual regions now are going to their drawing boards. Some are multi-county, many are multi-county actually, that have a lot of different interests within themselves. So each region will create its own governing structure. All regions will have its own individual governing structure that then will be able to receive funds through the foundation to abate the nuisance, to abate the opioid problems that they have in each of their individual communities. So that, I think, addressed kind of the global issue of a direct sum payment of a couple $1,000s to a township or a small village or municipality may not be able to have this, the bang for its buck as it would if the region at large was able to band together in the aggregate to figure out what solutions make sense. In that same vein, relying on the foundation that's created and the experts that will be hired, I believe that a lot of the regions would be able to rely on those expertise to figure out, what is going to be effective and unique to them. Obviously, Region 1 of the city of Columbus and Franklin County, we are fortunate enough to have the Ohio State University. We have major hospital systems. We have research institutions. We are blessed to have more resources in our region than perhaps a more rural region has. And that's where the foundation, I think, in providing a resource can be very important. Equally so, again, to combat against any to combat against the concern that money was not going to flow directly to the cities and counties, is that there is an actual check that will be cut to individual cities and counties based on a formula. So that's real money that will be sent directly to those cities and counties that is separate from the foundation to address, again, some of those competing interests that were at stake when we all came on board to sign on to the One Ohio plan. So I think what the One Ohio plan does its best at doing is taking a lot of diverse interests and coming up with what is the most original and unique plan to address a lot of different interests, so that small counties and cities feel like they're getting a fair shot of the ability to abate the nuisance, the opioid epidemic, and that larger in cities and counties also feel like they are getting their fair share to address what they have done. And that's where the uniqueness of this settlement, I think, comes into play, and the testament to the leadership of Jonathan and others has really set Ohio apart. And I'll close by saying there's a real recognition, just like, lawyers often the phrase race to the courthouse to see who's going to file first to be able to direct and control litigation. On the back end here, there's really a race, I think, to settlement, because there's a realization that money is not unlimited here, and that as cases continue to go to trial, while these companies certainly have a significant amount of resources available to them, it is not unlimited. So how does Ohio jump to the front of the line, put its stake in the ground, and have a guarantee that money will flow, as Jonathan mentioned, just over $800 million. Otherwise, if you wait for your turn to litigate or wait for your turn to settle, that money may not be available. And I will say, and this is just, honest talk, the state of Ohio, as its own individual litigant, was ahead in the litigation line to go to trial in state court ahead of the MDL litigation, where most of the cities and counties in Ohio. So the state of Ohio itself, through the Ohio Attorney General's office, they had the real recognition of leverage of moving ahead and potentially getting a significant settlement that, again, would take away from that pot of money that's available for other plaintiffs in the MDL, like Columbus, like Franklin County, and others, to take advantage of this. So going into any settlement, as you all know, as lawyers, you have to weigh all the different factors and come to a conclusion. And One Ohio, I think, was the best balance of a lot of different interests, accepting a lot of different realities that we may not like the realities, but they're there, they're real, they're the facts of the case, and ensuring that our communities that we're representing, the 900,000 people in the city of Columbus, that they're going to get their fair share to make a difference for them and their families to abate the opioid crisis in our own backyard. And I'll stop there. Happy to take questions at the end.
Hi there, everyone. I'm Christine, and hello from Seattle, where it is very stereotypically Seattle outside, as you can see. I walked out into my living room, which is where this home office is, this morning, and we were legitimately in a cloud. I'm on the 21st floor, but it looked a lot higher just because the cloud was just so low. But anyways, greetings from Seattle. By way of introduction, I feel like I should talk about how I came across One Ohio to begin with. I track states' publicly reported opioid settlement spending plans. And I do this using my Soros Justice Fellowship grant. I launched opioidsettlementtracker.com using my Soros Justice Fellowship grant as like seed funding, so to speak, back in 2018. And my fellowship technically ended in May, but I've been fortunate enough to convert some of my fellowship work into a type of consultancy of sorts, where I now spend most of my time working on state level advocacy projects. And I got into opioid settlement related things as a student at the University of Washington School of Law here in Seattle. And I mentioned this for the benefit of any law students in the house looking to pursue non-traditional paths after law school, which by definition probably includes anything related to drug policy strictly. During my 2L year, I published a piece about the opioid MDL regulatory capture and the war on drugs broadly with the Harvard Journal of Law and Public Policy. And then I spent my 3L year working as a municipal prosecutor and hunting for a grantor who would let me go off and answer the question that still energizes and animates my work today, which is, will states and localities spend their opioid settlement dollars well, or are we going to have all of these annoying campaign for tobacco-free kids-esque retrospectives here in a couple decades time that'll say that all of these billions were spent on the wrong things? I've been doing this since 2019. And at this particular juncture, I'm happy to report that as somebody who, reads Google alerts related to the opioid litigation, its related settlement negotiations every day, and as somebody who's been tracking the state's settlement spending plans specifically since February, I can state unequivocally that the stuff legal academics and public health experts used to fantasize back in the day as like possible solutions or possible ways to ensure responsible spending. At the time, they were talking about things like legislatively enacted special funds or approved purposes lists sourced from evidence-based recommendations from actual public health experts, or like reporting requirements. So they were talking about that kind of stuff. Those things are aspects of real life plans that we have today. And I think that's really exciting. Sometimes I get requests from very pessimistic journalists looking to like what I call Chicken Little for clicks, and write pieces explaining how states will inevitably squander their opioid settlement funds. And they want to write these pieces even before they've done a due diligence dive into states' plans or realize that states don't even have the bulk of their money yet. And when I get these requests, I get a little bit defensive because the amount of advanced preparation and planning required from the participating jurisdictions, even before this January 2nd political subdivision sign-on deadline that's coming up, for instance, the amount of energy required is tremendous. And the type of cynicism that would minimize the sheer amount of effort that's been expended thus far through all of these legislative proposals I'm seeing, the interbranch governmental planning, the state local sign-on campaigns, the type of cynicism that would just flatten all that, I think is pretty corrosive. So I don't like to boost the page views of those perspectives that seem determined to not give due credit where credit is due. So only time will tell how this money will actually be spent. But I can say that the more time I spend looking at states' plans, studying their allocation structures, trying to understand which committee oversees what and how much power they have, et cetera, the more I walk away feeling that on the whole, we at least have a good faith, self-aware national effort to not repeat some of our more egregious spending mistakes of the past. And we have those promises in writing, and that's nothing to sniff at. So to get a little bit more into specifics, right? So I mentioned that I've been tracking state settlement plans since February. Opioidsettlementtracker.com/settlement spending houses that 50 state survey I completed with fact-checking assistance from the Johns Hopkins Bloomberg School of Public Health. They've been instrumental to me, and it's just been so nice to have the institutional heft while taking on a project of this size. But our spreadsheet, I should note, actually contains more information than what the Plaintiffs' Executive Committee lists on its own website, nationalopioidsettlement.com, likely because we're tracking pending motions and pending legislation as well. So consider our spreadsheet the superset, perhaps the less admissible superset, because what exists on the Plaintiffs' Executive Committee website, it suggests that it satisfies some of the more technical requirements as laid forth in the National Settlement Agreement document. So consider like our spreadsheet, not hearsay, but something that would be admissible in a grand jury indictment, and then consider the Plaintiffs' Executive Committee list on their site, what would satisfy, stuff that would satisfy federal rules of evidence. So that is the dorkiest analogy I've made today. So anyway, I invite you to read through some of those plans and other states' plans as well. Though I will say that One Ohio is extremely special to me because it was the first plan that I thought was genuinely fleshed out and interesting. I think Jonathan mentioned this. It was March when Mike DeWine and Dave Yost made that joint announcement. And at that point in my research, states fell into two categories for me. Those making promises as to spend via legislation, like those state legislature bills attempting to create special opioid abatement funds, and those who hadn't done so yet. So when I started noticing Ohio and some other states making promises as to spend via contractual state local agreements, now, typically we know they're called now a memoranda of agreement or memoranda of understanding, like Ohio's MOU. I started tracking those documents as well. And I didn't know it at the time, but through this whole process, I was basically like forensically reconstructing the requirements being discussed in national settlement negotiations, because when the actual offer documents, I suppose, the settlement agreement materials came out on January 21st, and I need to be specific here. This is the offer, the $26 billion offer that's widely reported from 4 specific companies, right? Johnson & Johnson, McKesson, AmerisourceBergen, Cardinal Health. So when these documents came out, like everything clicked into place. I don't know if anybody in the house looks at memes, but the meme where like the code is scrolling and the person looks just so dumbfounded with an epiphany, like that was me, because everything I was seeing started to fall into a framework that made total sense to me. Because if you read through the distributor and Janssen documents, which are linked on my site, you'll learn that 70% of states' monies are, and this is how a very helpful person who was recently at the New York AG's office explained things to me, and I believe he's present in the audience, so hello. So the way that he explained it, 70% of states' monies are restricted solely for abatement purposes, while 30% is not, And the documents propose a default 50-50 split of those unrestricted funds between state and local coffers, which means that there's a default allocation, like a default state-local allocation proposed by the settlement docs themselves. They propose 70% to an abatement fund, so 70% of a state's entitled slice of that $26 billion pie to an abatement fund. 15 the state can reserve for itself, and 15% goes to localities. But if states don't want to follow this allocation, and if they want to divvy up that unrestricted 30 a different way, or hit that 70% for abatement minimum threshold differently, they need to take one of three actions, all of which have been the very things I started to track at the beginning of this year, which is wild. Specifically, and according to section 5D, which I think you can find page 32 of the distributor agreement, specifically to pursue an alternate non-default allocation, states must enact a state subdivision agreement, contract, a statutory trust, legislation, or an allocation statute, legislation. And at this point, I'd love, obviously One Ohio, the MOU is a state subdivision agreement that does alter the default allocation. I don't know if we've discussed this in prior panels, but the allocation that One Ohio is pursuing is 15 for the state, 30 for localities, and 55% to the One Ohio Foundation. And while I'm happy to talk about the things that I think are unique about One Ohio's plan against the backdrop of bird's eye information I have of the other states' plans, I think it might be interesting to talk a little bit about data and to give you a sense of where Ohio fits in national trends. So I mentioned that I'm working on, we are actively updating, as we speak, a 50-state survey of state settlement spending plans, publicly reported plans. And that's available on opioidsettlementtracker.com/settlement spending. What Johns Hopkins, Bloomberg, and I are finding is that there's great variation across states as to specific details of their plans, the allocation ratios, the quality of advisory committees, who has additional reporting duties, things like that. And all of this means that whether states plans are normatively good or bad at this stage is conclusively a state-by-state analysis. So avoiding the normative discussions for now, and speaking at a very high level, I'd love to show you some slides that contain some data I've been working on. So at this point, I'm going to screen share. Hopefully nothing will collapse on me. Here we are. Okay, so again, that's the URL for where you can find some of my work. Caveat before I get into this, the states I'm listing, and so if I say X state has, is pursuing, an allocation statute, I'm talking about publicly reported stuff, and I've made the distinction between our list, which is the superset of the plaintiffs, executives, committees list on the nationalopioidsettlement.com website. I've made that distinction prior, but a more nuanced one here. The stuff that I'm going to be talking about, publicly reported. There are things that the plaintiff's executive committee will list on their site that for us, the team at Johns Hopkins, Bloomberg, and me, we consider still pending. For instance, New Jersey's plan, while listed on National Opioid Settlement, nationalopioidsettlement.com, New Jersey's plan was actually recently conditionally vetoed by the governor at the end of November, I believe. And that update has not been reflected on the PEC's site. But in any case, so that's a caveat, right? This is publicly reported information, not necessarily technically approved and effective. So to get into this, just a level setting exercise. Here's a table of contents, I suppose. If you want to look at what the language specifically states. If you're curious about what I'm talking about and want to actually look at the language, go to section 5. The definitions of a state subdivision agreement, allocation statute, statutory trust. The takeaways for our purposes to know a state subdivision agreement is a contractual agreement, and an allocation statute and statutory trust are considered legislative actions. So having said all that, here are the states that are pursuing state subdivision agreements or who have publicly reported ones. Here are the states that have publicly reported, in legislative databases, allocation statutes. And here are the states that have established through their legislative processes, statutory trusts. You'll notice that some states have asterisks. That's there to indicate that they also have a statutory trust written into their legislative codes in place. And as I mentioned, New Jersey is an interesting case where their plan was actually conditionally vetoed by the governor. So we'll see if the legislature actually reintroduces it next session. Silent, gridlocked, and other. This is my least favorite category because it's just so hairy. This contains a list of states that, have either we've only heard crickets from them, or they have hard fought battles that just have not panned out yet in bills that have been passed. And this section, I'm the most hesitant to show because this is the most, this is a category most in flux, right? Georgia, for instance, was originally a non-participating state, a state that had publicly stated, like, no, we're not going to be participating in the National Settlement Framework as proposed by Johnson & Johnson, McKesson, AmerisourceBergen, and Cardinal Health, but then they came around and came out with a plan. So that's the fuzziest category for me, and I'm sure Zach and Jonathan, if you guys have amendments, by all means, I'm all ears. But for our purposes, let's just look at it this way, right? About 40% states have publicly reported state subdivision agreements. The second most populous category, that very hairy, silent, gridlocked, or other category. And statutory trust and allocation statutes are the less favored option. And of course, we have the non-participating states. So that's how it looks as of yesterday, information available and publicly reported as of yesterday. You'll notice that, I split these out into two categories or two columns, if anybody was curious as to why. It's because I've broken them out according to which states are proposing an allocation that differs from that 15-15-70 thing I mentioned. Obviously, you guys are pursuing something different, which is why you are here. Some states are pursuing something different via allocation statute. And the statutory trust states, like, they haven't really, pursued anything different from 15-15-70, which I think is interesting, but also makes sense if you look at the definition of what the statutory trust is typically tasked to do. So obviously, I'm curious about this category, right? Preliminarily, I can show you this language. So of the states pursuing alternate allocations, you pull language from their state subdivision agreements and their allocation statutes, and you get a little bit more information as to what they're thinking. If not 15-15-70, how are we gonna divvy things up here? And the language fleshes that out. And of course, I'm curious to see which states are reserving more for themselves. Here we are, as indicated in red. But if you really dig into states' plans, you'll learn that the entities tasked with decision-making powers or recommendation-making powers, those rules are nuanced state by state as well. So I've highlighted for you in purple states that are making heavy investments into their abatement-related funds. So these are the states where the rules for who controls the purse strings and who can actually make allocations from the fund and how grant-making procedures work. These are the states where those rules will become very important. So as I said, all this information is available on my website. At this point, I should probably stop sharing and get back into what I consider a very necessary explanation of this data. Just very quickly, I should note for you some things that I've taken away. It's related to these allocation slides specifically. These days, I personally tend to shy away from debates about which level of government should control the purse strings, ought to have more of the money. Because if you approach it from the perspective that the goal of these plans is for a sovereign state to work with its political subdivisions to save as many lives as practically possible, using these settlement funds to abate what the overdose crisis looks like in that particular jurisdiction, you then have to anticipate and be tolerant to an array of quirkiness to states' approaches. And as I mentioned, ultimately time will tell whether or not these funds will be spent effectively, right? But for now, when met with a very human desire to judge whether or not a particular state's approach is normatively good or bad, might I suggest to you a perspective I use these days, which is to explore the difference between a plan's procedures and substance. And this is all, obviously, I'm speaking to our audience of legal nerds here. Examples of procedure, what does the state's reporting requirements look like? What additional requirements that is the state putting on itself? How effective are its processes for collecting the best information out there, either by expert opinions or community input? Does this plan relate to McKinsey monies, any McKinsey monies still remaining in a pot, or do these rules solely address funds from those 4 offeror companies? An example of a substantive analysis might be a subjective assessment of whether you think the plan is like woke or harm reduction friendly enough, or a policy analysis of whether or not some of these interventions ultimately uphold the carceral state, stuff like that. You know, because I do believe that these plans will require, you know, we'll need the watchdog entities, we'll need the interested minds, we'll need considerations of enforcement, perhaps ombudsman, creative solutions like that, if only because the scale of this effort, the scale of this coordinated effort is just so insanely vast at a national level. But at bottom, these documents, the MOUs that we're seeing, the statutory trusts, the allocation statutes, these documents are ultimately serving as receipts for the general promise that opioid settlement monies will be spent more responsibly than big tobacco settlement monies were. And that's very exciting. And at the end of the day, you know, now governments have this tremendous opportunity to either restore or reaffirm, I guess, depending on your politics, the public's faith in their ability to take care of its people and spend money wisely. So those are my thoughts. And at this point, I'm going to hand off the mic, the conch, Lord of the Flies speak, to our wonderful MC.
All right, well, thank you so much to all of our speakers. And we've got about a little bit less than half an hour for discussion. We've got a few questions in the Q&A already. And then if people have additional questions, now would be the time to put them in the Q&A. So I just want to start, well, first of all, I just want to echo Christine's appreciation of our public officials in Ohio for getting together and getting really ahead of other states and thinking through how the state and local governments can work together and come up with a plan that is responsive to the concerns of lots of different jurisdictions, which is definitely not an easy thing to do. I want to dive in a bit more to the One Ohio plan and what exactly that looks like. But before we do that, maybe just wanted to start by going back to Jonathan Blanton and asking if you could just give a quick update on the other litigation and proceeding that is still ongoing, sort of what is still hanging out there. And then also, you know, what is the plan for integrating if there are other judgments or other proceeds that come in? What is the plan for integrating that into the One Ohio framework?
Absolutely happy to do that. So in terms of litigation that is remaining, we do have one defendant left in the pharmaceutical distributor case that is in Madison County. That's Miami Lucan. However, that company has pretty much ceased to do business. So the likelihood of a substantive recovery from them is pretty small. In terms of the manufacturers, we initially filed an action. We filed initial action and filed a amended complaint, naming Purdue Pharma, Mallinckrodt, which is a generics manufacturer, Endo, Teva, Allergan, and Purdue Pharma, as lots of folks know, is currently in the throes of bankruptcy. The plan has been initially confirmed, but is up on appeal at the District Court for the Southern District of New York, and will likely make its way to the Second Circuit before this is all said and done. Monies coming through the Purdue Pharma settlement will be directed in accordance with the plan and Judge Drain's order. So that will look maybe a little bit different than One Ohio. We'll work through how that is with our subdivision partners once that comes in. Mallinckrodt is also in bankruptcy, so that will be controlled by a plan. The states are working with the Planning's Executive Committee there to try to arrive at, you know, some sort of a meaningful resolution that, you know, provides some substantive relief. The other companies, Endo, Teva, and Allergan, there are some discussions ongoing with them. That case against those three companies is pending for the state of Ohio in Common Pleas Court in Ross County, Ohio. We're in the midst of discovery. We do not have a current trial date. I don't know where things stand with the subdivision litigation against those companies. At one time I knew. I don't believe there are additional bellwethers set against them in Ohio, at least, but I could be wrong. The future of other settlements, it depends a little bit well, it depends a lot on how they're structured. One Ohio applies to settlements that are entered into in partnership with the state and local governments. I suppose there could be settlements where a company would decide to settle with the state alone, or I suppose there could be a scenario where they would settle with a group of political subdivisions alone. I don't know that either of those is tremendously likely right now because of the activity in the MDL and the potential for providing global relief and broad spread peace that something like One Ohio provides. So it is, best of my knowledge, Attorney General Yost and Governor DeWine's plan that if we are able to bring other companies to the table, we would plan to convene the One Ohio Negotiating Committee, join again with our political subdivision partners, and try to get the best outcome for Ohio and put the money to work through the One Ohio plan. And that's largely because of the way it is structured and the safeguards that are in place and the designated, pretty detailed abatement purposes that the monies have to be put toward.
Great, and we're getting a couple more questions coming in now too that I will get to in a second. But I wanted to go back to Zach Klein first. You answered one of the questions that I had, which was about how the regional structures were going to be set up. So apparently it's going to be each region is going to figure that out and what it looks like. So I was just wondering if you could give a little bit more of an update about where that process is for Franklin County and Columbus, and then reflecting some of the questions that have already come in. What is the process for people if they want to get involved? Is there going to be an open call for people to be able to participate? And the specific question whether Columbus is going to prioritize the lived experience of people in recovery as part of putting together that recovery board.
So we're in the very early stages of getting together Region 1's board and what it's going to look like from a governing capacity. So there's two sort of open questions. There's Region 1's representative on the state of Ohio's foundation board, like that needs to be addressed. But then there's the Region 1 governing board itself, and those who are participants on the Region 1 governing board may not be the same person that is the Region 1 representative to the One Ohio Foundation. There may be the same person, it may not be. There's no guarantee. So in the early conversations with the city and the county, we recognize that while the city and the county entities themselves make up a vast percentage of Franklin County, we still have other suburban friends that we try to play well in the sandbox with and deserve to have a seat at the table, and trying to figure out, again, in these early conversations, what the board would look like to ensure that all perspectives ranging from municipality to township to county, but also health experts, lived experiences, how that is all reflective on the Region 1 board. So I don't have a specific report to share with the group other than to say we are in the very early stages, understanding that Franklin County is diverse, the city of Columbus is diverse, and that our Region 1 board, while needs to be nimble enough to be able to identify how funds should be spent, we don't want it to be a 30 or 40 person board because then it becomes bogged down in its own board bureaucracy, but it also needs to be reflective of how appropriately the money can be and should be spent in Region 1. Great.
And I guess this is a question either for Jonathan or Zach to follow up on, but I'm going to go to the questions that we have in the queue now so that we can have time to answer some of those. But one of the questions was about, Jonathan had mentioned strategies for sustainability as being built into this. So I was wondering if you could maybe talk about that a little bit more and what the thought is in terms of the One Ohio Foundation maybe being able to bring in and raise funds apart from the settlement, given that given the scope of the crisis, even this massive settlement is probably not going to be enough.
It's absolutely not going to be enough, and that is why sustainability is such a key part of it. In terms of what's built in, is sort of a lot of hope and a desire for innovation and ingenuity. The reason we with our local subdivision partners and the folks in the room, one of the big reasons we looked at the foundation was because of the ability to solicit grants, to solicit donations, to engage in hopefully maybe some corporate partnerships, to bring some more dollars to the table. The state dollars are going to be limited, local dollars are going to be limited, and those are always going to rise and fall on tax revenue and the state of the economy. And something as important, as expensive, and as unfortunately long-term in duration as recovery from the opioid crisis can't rely on those types of things. So this is going to be the foundation gets up and running. We're hopeful that they're going to start engaging the philanthropy community, to start engaging business community, to start engaging granting opportunities, to try to make that pot bigger and grow what we have to do the most good.
So I want to follow up on a couple things that I don't think that the speakers were on the previous panel, but just wanted to follow up on some of the conversations that we have then that maybe you can provide some more insight on. So I think one question that came up on the previous panel, and I don't know if Christine, if you've looked at the Ohio documents well enough to have a read on this too, was flexibility in terms of how the One Ohio Foundation and the different regions are going to be able to spend the money, and in particular, whether the money will be flexible enough that it can be used for other crises beyond just opioids, other drug-related addiction challenges, but also, whether there's flexibility to get at some of the broader social determinants of health that drive opioid use in the first place. So, issues like education and housing that are not in the sort of direct box if you think about opioid prevention, but are what we know from the public health research is critical to actually preventing and addressing opioid use. So I don't know if you all are, I don't know who's the right person to address that, but anyone have thoughts on those pieces of it, sort of the flexibility that the One Ohio Foundation, both at the state and the regional levels, will have?
I'm happy to double up with Jonathan with my answer because I'd love to talk about the issue of supplantation. But if that's something Jonathan or Zach, which I prefer to chime in on. So supplantation is, an important topic. Unfortunately, when it's talked about, rarely is the actual word ever used. I mentioned earlier that I'd be happy to talk about some of the things that stuck out to me about One Ohio, which I have to state at the outset, One Ohio has a very special place in my heart. So this is like when you give a family member like critical feedback or whatever, it's like done out of love, right? So I will say that One Ohio, the language of the document itself, the agreement itself, has a notable lack of straightforward reporting requirements, one, and a lack of acknowledgement as to the risks of supplantation. So supplantation, and feel free to jump in, as needed, Jonathan, Zach, but supplantation, let's to level set the definition. It's when a government reduces funds for an activity, specifically because alternate funds like a legal settlement or federal grant are or will become available to fund the same thing. In the opioid settlement context, supplantation occurs when a state or local government uses settlement funds to pay for things it should have been paying for anyway if those funds didn't exist. Supplantation is evil twin of supplementation, right? Supplement is to add to, and supplant is to take the place of. And to illustrate the existence of supplantation in the public health spending context, people just generally gesticulate in the direction of big tobacco. But when it's talked about in the opioid settlement context, some states do this very explicitly. For instance, Massachusetts Statutory Trusts, their language states, quote, "These funds will expand access to OUD prevention, intervention, treatment, recovery options, and will supplement, not replace, existing funding streams." So that's pretty explicit. New York's bill 7194, New York's bill says, quote, "Funds shall not supplant or replace existing state funding." So those are, they actually use the word supplantation. Other states dance around the issue with language that sounds good, but doesn't really address supplantation. An example of this would be all opioid funds, regardless of allocation, shall be utilized in a manner consistent with the approved purposes definition. And Ohio, I will say, falls into the latter category where it's not talked about or talked about ambiguously, because the language I just read is actually just from the MOU. So I would say as you know, the language, I can speak to the language itself, right? Not to how things will be administered, not to how things will actually play out IRL in the future. But even if it's just lip service, and even if it's assumed that these funds will not be used to supplant existing funding, it's important to put it in writing, especially when other states are doing it. So that's the thing I'll say, and you know, hand it off to whoever.
I don't think that's a, go ahead, Zach.
No, go ahead, Jonathan. Go ahead.
I don't think it's an unfair criticism or an unfair comment on One Ohio in terms of reporting and in terms of the supplantation. But what I can tell you is one of the reasons that the foundation is so important is because that is run by, you know, a board of directors, and also there is an expert panel in it that will be vetting the plans after they come up from the regions to look for this kind of innovation. In terms of, and I imagine Zach's gonna hit on this, but the importance of providing flexibility to local governments in their response was a key part of negotiating One Ohio and bringing, you know, the local governments on board, because the pressures are unique, city by city and county by county. So Zach, I'll let you take that.
No, I was just going to recognize that the criticism is legitimate and well accepted. I'm unfamiliar with what other states have done as it relates to getting 90+% of municipalities on board to sign off on their own proposed structure. And maybe several states have done that. Maybe Ohio is the only state. I honestly don't know. But I will say, being in the room and trying to negotiate language that would satisfy 90+% of municipalities that range from the 14th largest city in the United States, Columbus, 900,000 people, down to the smallest village or township. You know, there were a lot of disparate voices that ranged from, you know, we want to have unlimited control of our money, that if we want to spend it on, you know, whatever, we should be able to, this is our money, ranging up to this should opioid only specific money and no dollar should ever go elsewhere. And so, like, how do you balance those to find the guardrails that I think are important and necessary to address the issue, but flexible enough so that every city is able to sign on? And like the best kind of example, or that was used in the room, I should say, more over again, is like, this money shouldn't be used to fill potholes. And I think everyone generally agreed with that. The only pushback were some cities that said, hey, we spent the past 2 years funding overtime for EMS and for police because of opioid, and we shut down a rec center. So we should be able to use this money backward looking to, you know, to fund our rec center, because we've already spent the money the past 2.5 years that we'll never get back. So this is our rebate. This is our refund for the money we spent. So those voices were also in the room. And that's kind of, you know, from a deal making perspective, to satisfy a lot of disparate interest, I think we came up with flexible language that allowed each individual municipality to deal with the issue, but also recognize the money shouldn't be used to fill potholes.
Yeah, and I mean, I really appreciate the efforts that you made to think about the lessons of the tobacco settlement agreement, where the money literally was not only spent to fill potholes, but was used to pave roads to tobacco factories in the case of North Carolina. So I wanted to just talk for a second about the legal piece of this. Again, you know, I come at this from thinking about the tobacco settlement agreement and that experience that I lived through. So in the tobacco settlement agreement, the attorneys general who signed that agreement said that, you know, while they wanted the money to go to tobacco prevention and cessation, their view was that, you know, legally they were uncertain whether or not they could directly allocate the money in that direction. And, you know, so they felt that they had to have the money go to the states and then have the state allocate the money, which, as we saw, did not work out super well. So so the question, I guess, would be, was to the extent you're able to answer it, was that assessment by the AGs at that time wrong, or is there sort of clear legal authority to have this money go directly to the foundations as proposed here, which I think is great for public health purposes. But I guess I just want to ask about the legal question. What is the sort of legal authority that allows that to happen?
I think there is a difference, and there's the key difference with the opioid cases versus tobacco, where tobacco you had just the attorneys general resolving. There are a few cities and counties, I guess, that did have independent litigation, but not by and large. Is the manner through which this was resolved. It was a settlement agreement, agreed dismissal and settlement agreement in Madison County Common Pleas Court, but the settlement would not have been possible without participation from local governments. And the part of the participation of local governments hinged upon establishing a mechanism for, and well, from the attorney general and the governor too, hinged upon creating a mechanism that would be a safeguard against that type of diversion or repurposing, for I guess it's a more polite term. So if it were an AG only settlement, I think there would be some potential questions there. Although the attorneys general do have authority under the Cypre doctrine to provide money for purposes that are of public use. But here, because we have our city and county partners in the villages and townships together, entering into this, and the company is essentially making, I suppose you could call it a voluntary contribution. If you think of voluntary as having a gun to your head and saying pay the money or else, to this separate entity in a manner that does not ever touch state coffers, never touches an AG account, then I think we're on good footing. And sometimes you've got to be innovative when you're doing the public good.
And just kind of add what Jonathan said, there's a level of shielding, I think, because it does go into a private foundation that is represented by local governments and the state and representatives from the state. There's a level of protection, I think, that takes it away from the legislature's hands or the governor's hands to be able to do the securitization aspect of what happened with tobacco.
So I've got a question in the queue from Dennis Gushon from Harm Reduction Ohio, asking about how the 15% of the money that goes to the state is going to be spent, and who's going to control that money. I would assume that goes through the legislature, but wanted to confirm that. And then I'll just ask the parallel question about the money that is going to the city and whether there's been any. I assume that also likewise goes through city council, but whether there's any discussion so far about how that money is going to be spent.
So the terms of the settlement agreement itself with the companies designate how the money is to be spent, and that is for abatement purposes. The Attorney General is in discussions with the legislature, legislative leaders on how that will look, what mechanism will be in place, but it will, in the end, it will be legislatively driven decision making on Ohio's dollars, because that's the allocation, appropriation, and spending process that the state follows on things like this.
It's not too different at the city level. The money will flow, council will accept it. It will come into our general revenue fund. The guardrails per the agreement will be there, and then it will be spent and allocated, at the request and proposal of the mayor with input from the council. And if it gets a majority of council vote, the money will be spent in that manner.
All right, we've got a couple kind of more specific questions that I think we can answer easily, or not easily, but quickly. And then I think that'll pretty much take us to time. So I'll just ask both of them and get them out there. So one, again, from Dennis is, the One Ohio agreement limits the foundation's executive director salary to about $140,000. And the question is that going to be a challenge? That seems low. this is Dennis's comment, that seems low for the task of managing more than $1 billion. Why was that limit put in place? So, and then this other question was about transparency of the settlement from David Nachman, who's was in the New York Attorney General's office, asking or saying Ohio is to be commended for its transparency. In the spirit of that, is it clear to the public of how much of the settlement proceeds are going to outside plaintiffs' counsel at each level of government? So if those are questions that I guess Jonathan is probably best positioned to take the first shot at.
Sure. So in terms of the transparency of what is being paid to, I'll start with the second one since it was asked second, and then I'll probably ask you to repeat the first one there real quick. But it was about the executive director. Sure. So in terms of the money that will be going to outside counsel, I think that's fairly well set out in the settlement agreement and the agreement. The state of Ohio's outside counsel for the Attorney General's office received with fees and expenses a little over, I think, $40 million. But that was separate and apart from the abatement dollars. That did not touch the abatement pot at all. Attorneys for the political subdivisions believe had, I think it's about a $23 million fee fund, $25 million fee fund, something like that, provided by the companies. And the balance of their fees, which are capped at max of 25% or the contract rate, whichever is lower, will be paid out of a combination of the local share and the foundation share, because the money is mainly benefiting local governments. I believe plaintiffs' counsel provided an estimate of what that may be, and it is in the settlement agreement with the pharmaceutical distributors. I don't have the page site in front of me, but that assumes a full draw on participation. In terms of the executive director, I appreciate Dennis's thoughts on whether that's going to be enough. It is, pretty significant salary. It's not certainly not paltry, but that was a discussion that that agreement really arose from conversations with local governments. They were very concerned that the foundation would become a sort of honeypot for someone, or that it would become a place where functionaries or favored persons could be placed at an elevated salary without necessarily having the right credentials for it. And when you started looking around the state salary tables in conversation with the subdivision partners and with the governor's office, that's where we landed. Will it be enough? I guess we'll see. If it is not, I suppose the foundation board could look at amending that. I think it would be a big lift. If I were them, I would be cautious of doing that, because the other thing we haven't talked about, while there's questions about transparency and accountability, all the spending will be public. Every dollar that goes out, whether it's by the state, by the local subdivision, or by the foundation, is going to be subject to public scrutiny. And I think the people of the state of Ohio are going to hold their government accountable if they start misspending funds. Everybody's been touched by the opioid crisis. Every community's been damaged, and it's certainly government's job to do what we can to fix it, and it's the people's job, I think, to make us accountable. And by the way, thanks, David, for the call out. David did tremendous work in the New York Attorney General's office. He was leading their opioid litigation over there, and haven't caught up in a while, but good to hear from him.
I think that's a great note to end on, and I really just want to thank Jonathan Blanton, Zach Klein, Christine Minhee, all of you for coming and sharing and being open about how this money is going to be spent, and the questions that are still out there, perhaps, about how this money is going to be spent. And thank you for your work on making the settlement come together as well. So really appreciative, and I hope people took a lot away from this panel. And I will turn it over to the Drug Enforcement Policy Center team to just let us know if there are any last words before our time is up.
No, I think we have handled it all. Thank you so much, everybody. And we will be posting the recording within the next few days.
All right. Thanks, everyone.
Thank you.